Hey, this is Alex Yoder with Pro Tip Tuesday, my favorite day of the week. And today I want to talk about legal advice and how we as landlords and property managers navigate getting different legal advice from different attorneys. You know, the thing that we should definitely be aware of as we are interacting in this world of legality is really the age of a bill and kind of how much it's been vetted, how often it's been seen in front of a judge, if there's any kind of history that we can lean on. Because when we're seeking legal advice on a bill that's been in place for 10 years, 99% of attorneys are going to agree on how to handle that particular situation. Even if the bill wasn't horribly well written, which unfortunately is often the case, we have case history to lean on. When we have bills like the bills that were passed last year, the bed bug bill is a great example. I've heard multiple perspectives on the bed bug bill and how much you can charge, or if you can charge at all, the tenant if they brought those bugs in. I think that's a great example. But we've also had bills on applications last year and an update to the warranty of habitability in Colorado. And now due to COVID, we're dealing with the CARES Act. And there's a lot of confusion. There are many attorneys that have a lot of confidence in their legal perspective, but they'll still leave language in their recommendation like should, using words like should and may be able to hold up, because they don't really know. We have a lot of people that we are interacting with that do have that confidence, and we need that confidence so we can lean on those folks. But until it's actually been heard and we have that case law, you just don't know. You don't know which way the courts are going to be interpreting that bill, because again, they're not always clear and it is often left up to interpretation. I'll talk about showings for a minute because that's a really good example that I had to deal with last week. We had 3 distinct attorneys in the Colorado market that had very different opinions on whether we can do showings. And that's because the regulations released by the governor in terms of essential services were not clear. And very similar to the CARES Act with some of the stuff regarding notices and this kind of thing, it's just not very clear, so you have different interpretations. For showing specifically, we had the 3 attorney perspectives that we had said, one of them said you can do showings, you can open up the door and step away and let them walk through by themselves, but you can't show the property, you can't walk through with them. Another perspective said you can't do any showings at all, to include self-show on properties. So if you're using like a Tenant Turner or a ShowMojo or a Rently to do a self-show via a lockbox key checkout, you couldn't even do that. And then a third perspective said, no, you can't go to the property, but you can allow for self-show only. And so it's just kind of interesting / challenging to figure out, okay, what the heck are we supposed to do as professionals, and which perspective are we supposed to lean on? I think that what you do is you choose the attorney perspective, and you should be getting multiple attorney perspectives, certainly when there are bills like these that haven't been fully vetted and we haven't seen them kind of play out and be judged. But get multiple attorney perspectives and kind of lean into kind of which attorney is closest to the issue, which attorney is at the table for the issue. And in this particular example on showings, the perspective that said, no, you shouldn't be showing the property, but you can allow for self-show, or there should be no reason that you can't allow for self-show. That was actually the Carr attorney, who is very much at the table negotiating with the governor's office and the attorney general. And so I tend to kind of take that opinion more seriously because of that and because of how close they are to the issue. So that's one thing that you can do, but certainly get multiple perspectives. Also know that even if they are confident in whatever bill they have an opinion on, until it's been heard, you just don't know. And so understand that's kind of the world that we are in until those things are heard. And also understand that even if they give advice today, their advice may change tomorrow. So for example, I did a video last week on COVID updates talking about lease renewals and how you can't give notice for any reason, even if it has nothing to do with non-payment for tenants to vacate. My perspective has changed on that in the last week because I'm getting differing attorney advice. And so it'll change on a day-to-day basis. And if you are viewing videos like this, either from an attorney or from me, stay tuned to new videos because my perspectives change over time based on what I'm learning on a daily basis and based on the way that we're seeing these bills actually interact in the real world in different cases. So just my long story short, be careful out there, get multiple perspectives, and consider how close they are to the table as it pertains to the perspectives that you are leaning into, so that you can hopefully be on the right side of that table when these things kind of go in front of a judge, should they ever need to go in front of a judge. And hopefully they don't, but sometimes they do. So it's good to be kind of positioned for success. So that is all for today. Alex Yoder, Dorman Real Estate Management, Pro Tip Tuesday. Be careful out there in the legal ambiguity that is our lives. Have a great rest of your week. Goodbye.